Special counsel Jack Smith appears to be in the final stretch of his investigations into former President Donald Trump. Smith has been looking into the possible mishandling of classified documents and efforts to obstruct the 2020 election. Now, notable development this week, Tim Parlatore, one of Donald Trump's key attorneys, announced he is leaving the team. Now, in addition to working on the January 6th investigation, he also played a key role in the Mar-a-Lago documents probe, including organizing additional searches at Trump Tower, Bedminster, and an office in Palm Beach, as well as a Florida storage unit. Parlatore also appeared before the grand jury for several hours back in December. And Tim joins me now. Tim, thanks so much for being here with us. I think everybody wants to know, after the news this week, why did you leave the former president's legal team?
So, as I said at the time, it had nothing to do with the case itself or the client. The real reason is because there are certain individuals that made defending the president much harder than it needed to be. In particular, there's one individual who works for him, Boris Epstein.
Hey there, it's Jack, and today's a good one. Lower courts are progressively categorizing more of Trump's alleged conduct as unofficial acts, with no immunity under the Supreme Court's framework, moving the legal system toward concrete consequences. What began as constitutional theory is now becoming a real shift in how presidential accountability operates. The ruling's most significant consequence for the ongoing criminal accountability picture has not been the absolute immunity protection it extended to core presidential acts. It has been the lower court's progressive evaluation of the specific alleged conduct in Trump's various cases against the official-unofficial distinction, and their consistent finding that the most legally consequential alleged conduct falls in the unofficial rather than the official category.
Who had really done everything he could to try to block us, to prevent us from doing what we could to defend the president. And ultimately it got to a point where it's difficult enough fighting against DOJ, and in this case, special counsel. But when you also have people within the tent that are also trying to undermine you, block you, and really make it so that I can't do what I know that I need to do as a lawyer. And when I am getting into fights like that, that's detracting from what is necessary to defend the client, and ultimately was not in the client's best interest, so I made the decision to withdraw.
Infighting is certainly nothing new in Trump world. Is there any specific incidents of something that he did to, as you say, prevent you from being able to properly represent your client?
Oh, sure. I mean, he served as kind of a filter to prevent us from getting information to the client and getting information from the client. In my opinion, he was not very honest with us or with the client on certain things. There were certain things like the searches that he had attempted to interfere with.
This is the documented, distributed, real version of the nuclear move that headlines are reaching for. The Raffensperger call placed by Trump in his capacity as a presidential candidate, seeking to preserve his electoral victory, not in his capacity as president, exercising any governmental authority, is unofficial conduct. The fake elector scheme arranged through the political campaign infrastructure, not through the governmental executive branch machinery, is unofficial conduct. The hush money scheme, a presidential candidate's arrangement for payments to suppress information damaging to his campaign, is unofficial conduct. Lower courts are progressively placing the specific alleged conduct that produced the most significant criminal accountability exposure in the unofficial acts category.
And then more recently, as we're coming down to the end of this investigation where Jack Smith and ultimately Merrick Garland is going to make a decision as to what to do, as we put together our defense strategy to help educate Merrick Garland as to how best to handle this matter, he was preventing us from engaging in that strategy.
You said that Boris tried to prevent you from conducting searches. What searches are those?
This is the searches at Bedminster initially. There was a lot of pushback from him where he didn't want us doing the search, and we had to eventually overcome him.
Why didn't he want you doing the search?
I don't know. Boris is, he is a lawyer. He spent about 18 months at a big firm doing transactional work, and I think he just thinks based on the experience he knows better than all of us.
So you previously testified before the grand jury back in December.
Yes.
Since you've left, some people have speculated that you couldn't represent the former president because you're a witness. What is your response to that?
That, unfortunately, it has a lack of understanding as to what actually happened there. So, first of all, I was not subpoenaed.
The category that the immunity ruling itself says carries no immunity protection whatsoever. This progressive lower court narrowing is the documented real version of the nuclear move. Not a single ruling pulling the nuclear option, but the accumulated judicial determinations that are progressively stripping the immunity's reach from the specific conduct most relevant to criminal accountability. The Raffensperger Call's placement in the unofficial acts category is the most consequential single lower court determination in this progressive narrowing, because it is the most publicly documented, most specifically quoted, and most legally significant single act in the Georgia election interference case. The Raffensperger Call was a phone call from a sitting president to a state election official during the period between the 2020 election.
What that was is the original subpoena to the office of the former president. They wanted a custodian of records to come and appear. They really wanted somebody, a staffer from down in Palm Beach, to come in and talk about, what searches were done so that they could beat him up. And ultimately, there wasn't really a good person on the staff to send, so I made the decision to go in myself and to face the prosecutors and to actually speak directly to the grand jury and explain to them what was really going on here. So as I went in and I talked about what we as a legal team had done in searching all the properties, that doesn't make me a material witness or anything like that. So there's no conflict. There's no issue where, I would expect to ever be called back in there. In fact, there were a couple of opportunities where I offered to come back. The prosecutors didn't want me back. So, it really has nothing to do with that.
So you recently sent a letter with the other attorneys on the legal team to the House Permanent Select Committee on Intelligence.
Yes.
And one of the arguments that you make is the reason these documents ended up in Mar-a-Lago is because...
And the January 6th certification, in which Trump asked Raffensperger to find the votes needed to change Georgia's electoral outcome. The Trump legal argument has been that the call was an official act, that a sitting president communicating with a state election official about the certification of an election result is exercising a governmental function connected to the president's interest in the proper conduct of federal elections. The lower court's finding is that the call was unofficial, that it was the conduct of a presidential candidate seeking to preserve his specific electoral victory in a specific state.
At the end of any administration, particularly this one, it's chaotic. And specifically, you said that the fact that these ended up down at Mar-a-Lago is, quote, indicative of the staff's packing process and not any criminal intent by former President Trump. The problem is the former president, his allies, and even at least one of your fellow attorneys have all publicly contradicted that explanation for how these things ended up down at Mar-a-Lago. I think there are at least 4 official explanations that they've put down about the status of these documents. I'm going to go through them chronologically.
Sure.
Starting shortly after the search warrant was executed down at Mar-a-Lago, some of the former president's allies came out and said that he had issued a sweeping declassification order on multiple occasions, so the documents removed from the Oval Office were deemed declassified when he removed them. Did you ever see any evidence of any such order?
I never saw the order itself. That would not be something that we would have access to. If it was a written order as opposed to an oral order, so I did not see that.
So the former president then, a couple of weeks later, said this to Sean Hannity.
Not the conduct of a president exercising any governmental authority over any aspect of the electoral process. That specific placement of the most publicly documented single act in the Georgia case in the unofficial category is the progressive narrowing's most consequential individual determination because it removes the immunity's protection from the specific act most central to the most advanced state criminal case. The Second Circuit's oral arguments on the immunity sliver argument in the hush money case are the specific ongoing appellate proceeding most likely to produce the next documented determination in the progressive narrowing. The immunity sliver argument asks whether any portion of the trial evidence in the hush money case touched on official rather than unofficial conduct. The Second Circuit's resolution of that question will either expand or contract the immunity's reach in the specific factual context of the hush money conviction. The prosecutorial position is that the hush money conduct is entirely unofficial. the conduct of a presidential candidate arranging payments to suppress information damaging to a political campaign. If the Second Circuit agrees that the hush money conduct is entirely unofficial, the immunity ruling's protection does not reach any aspect of the hush money conviction, and the 34-count guilty verdict stands without modification from the immunity framework. That determination, if it holds, is the nuclear move the headline is describing in the specific factual context of the one case where a conviction already exists and where a prison sentence is the specific consequence the immunity is being invoked to avoid. Let's go through the full picture. What the lower court's progressive placement of Trump's alleged conduct in the unofficial acts category means as the documented, distributed, real version of the nuclear move. Why the accumulated pattern of those specific determinations constitutes in its aggregate form the immunity protection being progressively stripped from the conduct most relevant to criminal accountability. What the Second Circuit's proceedings on the immunity sliver argument mean as the most immediately consequential pending judicial determination for the one case where a prison-eligible conviction already exists. What the Georgia RICO case's specific progression means as the state criminal accountability track where the federal DOJ policy, federal pardon power, and federal immunity ruling are all simultaneously least effective. What the immunity ruling's own language means for the framework within which all subsequent lower court progressive narrowing decisions are operating. And what the delay strategy's specific documented failures mean as the distributed real version of the last offenses being closed off. Each of those dimensions tells a specific part of the story of why the documented progressive narrowing is the real version of the nuclear move the headline is dramatizing. Start with what the lower court's progressive narrowing means because the specific pattern of lower courts placing Trump's alleged conduct in the unofficial acts category is the documented real version of what the nuclear move headline is trying to capture in a single dramatic ruling. The Trump versus United States ruling was a decision that gave the president the broadest official act immunity in American history, but it simultaneously established the specific constitutional distinction between official and unofficial conduct that makes the immunity scope dependent on the specific factual characterization of the specific conduct at issue in each case. The lower courts evaluating Trump's specific alleged conduct against that official-unofficial distinction have been consistently finding that the most legally consequential alleged conduct falls in the unofficial category. The specific pattern of lower court findings is the accumulated judicial determination that the immunity ruling's broad official act protection does not reach the specific conduct most relevant to the criminal accountability cases. That accumulated pattern is the progressive narrowing distributed across multiple courts, multiple cases, multiple specific determinations, but constituting in its aggregate form the documented real version of the immunity protection being progressively stripped from the conduct most relevant to criminal accountability. Now let's talk about what the Second Circuit proceedings mean because the specific legal question being evaluated, whether any portion of the hush money trial evidence touched on official rather than unofficial conduct, is the question whose answer most directly determines whether the immunity ruling's protection reaches any aspect of the one case where a conviction already exists. The Trump legal team's immunity sliver argument is that some of the trial evidence involved official conduct, communications that touched on official governmental functions in some capacity. The argument is that the trial record therefore contains evidence that the immunity ruling requires to be excluded because it was obtained through the use of evidence that falls in the official rather than unofficial category. The prosecutorial argument is that the hush money case is entirely unofficial, that the specific conduct at issue, the arrangement of payments to suppress information damaging to a presidential campaign, is entirely the conduct of a candidate seeking electoral victory, not of a president exercising any governmental authority in any official capacity whatsoever. The Second Circuit's resolution will determine whether any portion of the trial record must be excluded on immunity grounds, which could potentially affect the validity of the conviction, or whether the entire trial record stands as constitutionally permissible evidence of unofficial conduct entirely outside the immunity's reach. Watch the Second Circuit ruling as the specific judicial determination that will most directly answer whether the immunity nuclear move actually reaches the one case where a prison-eligible conviction already exists. Now let's talk about what the Georgia RICO case's progression means, because it is the specific state criminal accountability proceeding most likely to produce a prison-eligible conviction that is entirely outside the federal pardon power's reach and that the immunity ruling does not protect. Georgia is a state proceeding. Federal presidential pardons cannot reach state charges. The immunity ruling, a federal constitutional determination, does not protect against state criminal prosecution for conduct that falls in the unofficial acts category. If the lower court's progressive narrowing of the immunity's reach is correct, if the Raffensperger call and the fake electors conduct are unofficial, then the Georgia RICO case proceeds against Trump without the immunity protection, and the federal pardon power cannot reach any conviction that results. The Georgia case is the specific criminal accountability track where the three protective mechanisms, DOJ policy, federal pardon power, and immunity, are all simultaneously least effective. DOJ policy does not apply to a Georgia state prosecution. Federal pardons cannot reach Georgia charges. The immunity ruling's protection applies only if the relevant conduct is official rather than unofficial, and the lower courts are finding it unofficial. This creates a perfect storm of accountability where the usual protective mechanisms that have been preventing the most consequential accountability outcomes simply do not operate. Now let's talk about what the delay strategy's documented failures mean, because the specific pattern of courts finding Trump's delay tactics legally insufficient is the documented real version of the delay escape routes being closed off that the nuclear move headline is describing as a single dramatic moment. The denials of post-conviction immunity arguments in the hush money case are the specific documented judicial refusals to allow the immunity ruling to be used as a post-conviction escape hatch for a case that was tried without the immunity arguments being properly preserved. The characterization that the sentencing proceedings' burden on a sitting president was not sufficient to warrant emergency intervention is the court's own assessment that the urgency arguments were not compelling enough to justify extraordinary judicial action. The incarceration notice is the court's formal documentation of the incarceration consequence that the DOJ policy has been preventing from being enforced. Together, those documented failures of the delay strategy, each a specific documented judicial rejection of a specific escape route, constitute the accumulated judicial record of the specific post-conviction and post-indictment legal mechanisms that have been attempted and found insufficient by specific courts in specific proceedings. Each failure is individually less dramatic than a single nuclear move that closes everything off at once. Together, they are the distributed real version of the last defenses being progressively closed off. The documented evidence that the delay strategy is encountering consistent judicial resistance across multiple courts and multiple procedural attempts. Now let's talk about what the immunity ruling's specific language means for the prison before year-end's framing, because the ruling's own language in Trump versus United States establishes the specific constitutional framework within which all of the subsequent lower court progressive narrowing decisions are operating. The court said that the president is absolutely immune from criminal prosecution for acts within his conclusive and preclusive constitutional authority. The court said that the president has presumptive immunity for all official acts, and the court said that for the conduct alleged, the election interference, the fake elector scheme, the Georgia pressure campaign, the question of immunity is determined by whether the specific alleged conduct falls within the official or unofficial category. The lower courts applying that framework to the specific alleged conduct in each case are finding unofficial conduct in the most consequential alleged acts, the acts most central to the criminal accountability cases. The Second Circuit evaluating the hush money case is the appellate court determining whether the framework reaches a conviction that already exists, and the one case where the framework's application most directly determines whether a prison-eligible sentence can be enforced. The prison before year ends framing is the most dramatically compressed available representation of what the progressive lower court narrowing, the Second Circuit determination, the Georgia RICO proceedings, and the convergence together are building toward. The accumulated judicial record of the immunity's specific limits applied across multiple courts, multiple cases, to the specific alleged conduct where a prison-eligible sentence is the specific consequence at stake. The specific connection between the immunity ruling's three-category framework and the lower court's progressive narrowing is worth establishing precisely because the lower court's ability to progressively narrow the immunity's reach depends entirely on the immunity ruling's own establishment of the official-unofficial distinction as the constitutional boundary of the immunity. The immunity ruling is not being overruled or narrowed or ignored by the lower courts applying it. It is being applied exactly as the Supreme Court wrote it. The lower courts are applying the specific three-category framework the ruling established: absolute immunity for core presidential acts, presumptive immunity for other official acts, no immunity for unofficial acts, to the specific factual circumstances of the specific alleged conduct at issue in each specific case. They are following the Supreme Court's own remand of the official-unofficial factual determination to the lower courts, and their application of that framework is producing the specific determination that the most legally consequential alleged conduct, the Raffensperger call, the fake elector scheme, the hush money arrangement, the rally speech, is unofficial rather than official, and therefore falls in the third category, no immunity. The progressive narrowing is not the lower courts defying the Supreme Court or issuing their own counter-ruling to the immunity decision. It is the lower courts faithfully applying the Supreme Court's own three-category framework to the specific factual circumstances of each case and finding that the specific conduct at issue in the most consequential criminal accountability proceedings falls in the third category. The category that the immunity ruling itself says carries no immunity protection whatsoever. That specific constitutional dynamic is what makes the progressive narrowing analytically significant. It is the immunity ruling producing the progressive limitation of the immunity through its own three-category framework applied by lower courts to the specific factual circumstances of Trump's alleged conduct. 4 clean points on what the lower court's progressive unofficial acts narrowing as the accumulated distributed real version of the nuclear move, the Second Circuit determination as the most immediately consequential pending judicial finding for the existing conviction, the Georgia RICO case as the 3 simultaneously limited protections accountability trap, and the delay strategy's documented failures as the distributed escape route closing pattern together mean for the prison guarantee the headline is describing. Point 1. The lower court's progressive placement of Trump's alleged conduct in the unofficial acts category is the documented distributed version of the nuclear move the headline is reaching for, because it constitutes in its accumulated form the progressive stripping of the immunity ruling's protection from the specific conduct most relevant to criminal accountability. No single court has issued a single nuclear ruling that guarantees a prison sentence. Multiple courts in multiple specific cases evaluating the specific factual character of the specific alleged conduct against the specific official-unofficial distinction that the immunity ruling itself established and remanded to lower courts to apply have found that the most legally consequential alleged conduct is unofficial and therefore carries no immunity protection under the ruling that was supposed to provide it. That accumulated judicial finding is the documented real version of the immunity protection being progressively stripped from the conduct most directly relevant to criminal accountability. The nuclear move, compressed into a single dramatic ruling in the headline, is distributed across multiple lower court determinations in the documented reality. The immunity ruling that was supposed to be the broadest shield in American presidential history is being applied by lower courts in ways that leave the specific alleged conduct most central to Trump's criminal accountability exposure in the unprotected unofficial acts category. The nuclear move the headline is compressing into a single dramatic order is not a single Supreme Court ruling. It is the accumulated lower court determination that the immunity ruling's broad protection does not extend to the specific conduct at issue in the specific cases, and that finding accumulated across multiple courts applying the same three-category framework to different specific factual circumstances constitutes in its aggregate form the progressive stripping of immunity from the conduct most relevant to the prison before year-end's framing. Point 2. The Second Circuit determination is the most immediately consequential pending judicial determination in the prison sentence framing, because it most directly answers whether the immunity ruling's protection reaches any aspect of the one case where a conviction already exists and where a prison sentence is the specific consequence the immunity is being invoked to avoid. If the Second Circuit finds that the hush money conduct is entirely unofficial, as the prosecution argues, the immunity ruling provides no protection for any aspect of the 34-count conviction, and the conviction stands without any modification from the immunity framework. That determination, if it holds through any subsequent appellate review, including any potential Supreme Court review of the Second Circuit ruling, is the specific judicial finding most directly relevant to the prison before year-end's framing. The determination that the immunity ruling's protection does not reach the 34-count conviction that already exists in the permanent New York court record. And the specific consequence of that determination for the prison sentence framing is that the one case where a prison-eligible sentence is the specific immediate consequence, the one case where the immunity ruling provides no protection. If the Second Circuit agrees that the hush money conduct is entirely unofficial, watch the Second Circuit ruling as the specific pending appellate determination that most directly answers whether the immunity nuclear move was a paper shield or a real one in the specific factual context of the only existing criminal conviction. The one case where the three-category framework's application most directly determines whether a prison-eligible sentence can be enforced against the person who has been found guilty of 34 counts but has not yet been imprisoned. Point 3. The Georgia RICO case is the specific criminal accountability track where the three most powerful protective mechanisms, DOJ policy, federal pardon power, and the immunity ruling, are all simultaneously least effective, making it the specific accountability proceeding most likely to produce a prison-eligible conviction without the specific protective mechanisms that have been preventing the most consequential accountability outcomes. Georgia state prosecution, DOJ policy, does not apply. Georgia state charges, federal pardon cannot reach them. Georgia conduct, the Raffensperger call and fake elector scheme that lower courts are finding unofficial outside the immunity's protection. The Georgia RICO case is the specific criminal accountability proceeding where all three of the most powerful protective mechanisms, DOJ policy, federal pardon power, and the immunity ruling's protection, are all simultaneously most constrained, making it the specific accountability proceeding most likely to produce a prison-eligible conviction without the specific protective mechanisms that have been preventing the most consequential accountability outcomes in the federal cases. DOJ policy applies to federal prosecution, not to Georgia state prosecution by a county district attorney. Federal pardons are constitutionally limited to federal offenses and cannot reach Georgia RICO charges. And the immunity ruling's protection depends on the official-unofficial distinction, and the lower courts are finding that the Raffensperger call and the fake electors conduct that are the core of the Georgia case are unofficial. All three protective mechanisms fail simultaneously in the Georgia case under the lower court's progressive narrowing analysis, making the Georgia RICO case the specific accountability proceeding where the accumulated judicial limitations on each of the three most powerful protective mechanisms are simultaneously applicable. Point 4. The delay strategy's accumulated documented failures, the denials, the stay denials, the incarceration notice, are the specific documented judicial record of the escape routes that have been attempted and found insufficient across the post-conviction legal landscape. The nuclear move the headline is describing does not exist as a single dramatic order. It exists as the accumulated pattern of lower court progressive narrowing, post-conviction escape route rejections, pending Second Circuit immunity determination, and Georgia RICO exposure simultaneously operating against the same accumulated legal record. Watch the Second Circuit ruling as the most immediately consequential pending determination. Watch the Georgia proceedings as the specific state accountability track least protected by the federal protective mechanisms. Watch the convergence date as the time when the full accumulated record, the 34-count conviction's permanent existence, the Georgia RICO proceedings state immunity from federal pardon and DOJ policy, the preserved charges from the classified documents case, the election interference evidence record becomes most fully actionable without the specific institutional protections that have been preventing its most consequential applications. The nuclear move the headline is describing does not exist as a single Supreme Court order that drops and guarantees a prison sentence before the year ends. It exists as the accumulated progressive lower court narrowing of the immunity ruling's reach, the Second Circuit's pending determination about the one existing conviction, the Georgia proceedings immunity from federal protective mechanisms, and the conversion date when the institutional protections that have been containing the most consequential accountability outcomes are most likely to change. The prison before year ends framing is the compressed dramatic version of a legal reality that is slower, more distributed across multiple courts in multiple cases, and ultimately more constitutionally consequential than any single nuclear ruling could produce. A legal reality that develops through the faithful application of the Supreme Court's own framework by multiple independent lower courts is a more durable and more constitutionally grounded reality than a single dramatic order that could be appealed, reviewed, or reconsidered in a single subsequent procedure. The accumulated pattern is what matters. The progressive narrowing across multiple cases, the consistent finding that the most consequential alleged conduct is unofficial. The Second Circuit's pending determination about the existing conviction, the Georgia proceedings where all three protective mechanisms fail simultaneously. The delay strategy's documented failures across multiple procedural attempts, all of it building toward a moment when the institutional protections that have been containing the most consequential accountability outcomes finally give way. The nuclear move isn't one Supreme Court ruling. It's the accumulated weight of multiple courts progressively stripping away Trump's immunity. Each escape route is being closed, and the application of the immunity framework is making a prison sentence increasingly unavoidable.